Hi everyone, my name is Minnie vandePol and I am the Asia Pacific Head of the Compliance and Investigations Group. I'm delighted to invite you to join us at our upcoming event, The Future of Disputes, where my team and I will be discussing key issues for clients in the compliance and investigations space. In this podcast, I'm joined by Georgie Farrant, who leads the Australian Dispute Resolution Group and is also on our Regional Compliance and Investigations Steering Committee. Georgie and I will be giving you a snapshot of the latest compliance developments in Asia Pac, including some of the global trends that we're seeing and that are impacting our clients in this region. So we'll cover a couple of topics, the first being economic sanctions and geopolitical developments. ESG trends is the second of those topics. Georgie's then going to tell us about Australian developments and what's on the horizon. And then we will have a chat about anti-bribery and corruption developments more broadly, as well as what does a best practice compliance program look like. So let's just talk a little bit about economic sanctions and geopolitical developments, because as we all know, this is very hot in the press, and living in Hong Kong, I can tell you firsthand that it is a very real concern that clients have in terms of conducting business in the region, not just Hong Kong and China, but in the broader regional centres. So the use of economic sanctions against Chinese interests has then seen some countermeasures being applied by the PRC government. Following the release of the National Security Law in June of 2020 in Hong Kong, we saw responsive US executive orders from the Trump administration prohibiting certain investments and transactions which involve Chinese interests, including ByteDance, WeChat, and most recently, an executive order to secure the global supply chain relating to semiconductors, large capacity batteries, pharmaceuticals, and critical minerals for electronics. In response, we've seen the Chinese government releasing the regulations on the unreliable entities list, which is intended to blacklist and restrict the activities of entities that endanger Chinese national security. And earlier this year, China's Ministry of Commerce also released what we refer to as the blocking rules, which impose a reporting obligation where a Chinese party is prohibited from engaging in certain economic activities with a third country. So specifically, we see the blocking rules a bit like the EU blocking rules, intending to apply where the extraterritorial application of foreign legislation and other relevant measures are seen to unjustifiably prohibit or restrict Chinese citizens, legal persons, or other organisations from engaging in trade and business-related activities. So this is a little bit of a wait and see exercise, because we haven't seen what the blocking rules how they have been enforced in practice. And so that is certainly a topic that is of interest to our clients more broadly. ESG trends is also a very hot topic. As we know, ESG stands for environmental, social, and governance. And this area of compliance really has the effect of bringing together a number of different areas of compliance into a more connected and cohesive form. We're seeing in Asia that there are increasing local disclosure requirements, as well as various external drivers, such as legislation coming out of the UK, US, and Europe, where that voluntary approach to demonstrating a commitment to ESG drivers is less successful, and governments are now looking at mandating the requirement for companies to prove that they are ticking those boxes in a real and compelling way. And that's not just being driven by the government, it's driven by customers, employees, investors, lenders, and other stakeholders. So this is a very clear trend where we as dispute resolution lawyers are in a great position to be able to assist clients really understand where they stand on the ESG measures, how they can be seen as leaders, and how they can make sure that they are driving those requirements on the ground in the local markets where business is being done. Now, Georgie, I know that Australia is also focusing on different areas of corporate compliance and requiring businesses to perform perhaps better than they already are. Perhaps you could tell us a little bit more about what's on the horizon.
Yeah, and I think just touching on that point that you've just spoken about, Minnie, in terms of ESG, that is certainly an area that Australian companies, either voluntarily or being forced to, are focusing on more than ever. We're seeing it increasingly frequently in transactions where ESG due diligence is now part of the kind of standard areas that companies want to look at. And also some companies are being forced to look at it because there's actually been some really interesting public interest litigation where people are using the court system to effectively force companies to reveal more about decisions they're making in this ESG space, particularly in relation to climate change and particularly in relation to superannuation funds, where people are concerned about the decisions that funds are making in relation to the monies that are being invested. So we can talk about that some more on the webinar. But I think one of the key things from the sort of future of disputes, and a key factor which in Australia has really changed the landscape of the way in which investigations and dispute resolution is being conducted, is really the regulator's approach to the use of their powers and when they will take enforcement action. The best example of this is with the Australian Securities and Investments Commission, who has publicly stated that their new approach is why not litigate. So whereas in the past, companies might have felt that the most usual approach for the regulator would have been some form of enforceable undertaking or a negotiated position with the company, it's now much more likely that certainly that regulator and a number of the other regulators, if they think that there is a possibility of a successful enforcement action, both criminal and civil penalty actions, they're much more likely to go for it. And the levels of fines have been significantly increased in Australia, and the regulators are making full use of that. So really it is forcing companies to focus on compliance more than they have before, and really give very careful consideration to how they're going to interact with the regulators and decisions that they're making at an early stage, including in relation to things like privilege claims, where again the regulators are really taking a more strict approach and are not accepting claims for privilege that they might have accepted in the past. It's really forcing companies to focus at that very early stage. Another area of development that's been really interesting in Australia, and which I think is beginning to be echoed in other jurisdictions, and it also links into that kind of approach to the regulators, is the impact that whistleblowers are having on investigations and also flowing through to dispute resolution. There's been particular legislation in Australia which means that whistleblowers are being given even greater protections, which obviously means that companies are sometimes becoming aware of issues within their organisation more quickly than they would have done otherwise. But it also means that they've got to take an increasing level of care in the way that the whistleblower's identity is protected and making sure that they don't suffer detriment. And there's some failure to kind of heed those during the course of investigation can result not only in regulator action, but also claims from disgruntled employees. And so it really is something that the companies are having to think about very carefully from an investigations perspective. And it also ties in with another recent development from ASIC, which is the introduction of a new immunity scheme for whistleblowers who've actually been involved in certain types of wrongful conduct, including things like insider dealing or market manipulation. And if they are the first person to report that conduct to the regulator, they can get immunity from criminal proceedings or from civil penalty proceedings. But because it's not a protection that the companies can get, which makes it very different to the way that generally competition regulators around the world work, and which we know a number of our clients have utilised in the past, it makes it a very different proposition in terms of the way that companies need to consider the risks that are being introduced by that new regime. So I think that's a really interesting development. And again, we'll talk about that in more detail. And the final thing, which again at the moment is not Australian specific, but I think we're seeing it at the sort of highest level in Australia, is really that interaction between regulator investigations and class actions. And, very much they are going hand in hand at the moment. If a regulator is looking into something, you can guarantee that somebody will also be looking as to whether a class action is possible, and also vice versa. Sometimes something that the class action lawyers have identified can trigger off the regulators. And that can often mean that companies are having to address the same set of issues within different forums, both with the regulator and in the court actions. And again, there can be a real issue that arises in relation to privilege, where companies might want to give something to a regulator because they're being cooperative, but they don't want it to end up in the hands of the plaintiff class action lawyers. And we've seen that in a number of the sectors, in the financial services sector in particular, but also in a number of different sectors. So again, it's something that other jurisdictions like Thailand and Indonesia are beginning down that class action route, and I think we'll see that increasingly across the jurisdictions. And then I'll just touch briefly on and be interested in Minnie's views on the developments in other jurisdictions. But obviously, anti-bribery and corruption is a continual area of focus for companies in terms of their compliance and their investigations processes. And certainly in Australia, whilst we still haven't seen the developments that would bring Australia into line with some other jurisdictions like the UK, where although it's been flagged that we may bring in legislation to bring in the adequate procedures type of regime, and also the deferred prosecution agreements that we're regularly seeing in the US and the UK, those are still waiting a decision as to whether Australia will bring those in. But we are definitely seeing in Australia some high level prosecutions. It's certainly an area where there continues to be a focus, but not yet the legislative developments that some other countries have seen. And I might hand back to you, Minnie, to see what's happening in Asia in relation to that.
Sure, Georgie, thank you. You are right that, we have been waiting a little while for Australia to bring in legislation of the type that you mentioned. But in the meantime, we have seen Malaysia, which introduced its new anti-corruption legislation last year, and it has a corporate liability regime, a strict liability, just like the UK, in that you need to show that you have adequate procedures in order to defend a claim of a bribery or corruption issue. And we've seen, in fact, that the first prosecution has been brought under that new regime. So we're all very interested in seeing a bit more of what occurs in relation to that matter. It is a charge against a company and its director in connection with a count of bribery to secure a subcontract. So let's wait and see on that. Vietnam has also been very active, particularly last year. It introduced new anti-corruption legislation, and we've seen a ramping up of enforcement in that country as well. Although, having spoken to some of my colleagues in Vietnam, they have now got a new government, and we are waiting to see whether that government will be as active in terms of enforcement, because it has certainly come into force with a platform of highly active infrastructure and other projects in terms of stimulating the Vietnamese economy. So, that's often sometimes a little bit of a tension between trying to get business to act ethically whilst at the same time being successful. So again, we will wait and see what happens there. But I think all of that brings us back to, looking at your compliance program and making sure that it's fit for purpose. Does it respond to the new laws that are being enacted? Does it pay attention to what regulators are looking for on the ground? Does it also look at where headquarters of the company sits and the requirements of extraterritorial legislation, such as the Foreign Corrupt Practices Act out of the US or the UK Bribery Act? So that is important, because I think with the pandemic, we have seen quite a bit of pressure being put on compliance resources, on the ability for compliance teams regionally and from headquarters to be on the ground to assess the health of the compliance program, whether it is being properly implemented, whether it is properly understood, whether there are people coming to bring information about where things are not going as well as they should. And equally, we're seeing, that as I mentioned right at the beginning, that siloed approach of compliance, having the antitrust team in one corner, the anti-bribery and corruption team in another, sanctions in a third, human rights violations and supply chain compliance issues in another corner. These are really demonstrating where things can fall between the cracks and where compliance is not really responding to what the business needs in a very practical way. And so one of the things that we are looking at very closely, and we'll speak more about in the webinar, is how do you have a compelling, credible compliance program on the ground in 2021? With all those pressures that I mentioned and with all the developments that we're seeing, how do we do it in an efficient, cost-effective way? And it's not impossible. In fact, it is something that we would love to share some war stories in terms of the practical ways of being able to do that and supporting the business to become to be seen as a leader in terms of its ESG and other requirements. So, Georgie, I think it's going to be an exciting webinar, and I'm very excited to do this podcast with you and look forward to meeting up with our colleagues very shortly at the main event. Thank you.
Thanks, Minnie.